Today I would like to speak a little bit about transparency and accountability in the judiciary. Just by way of an introduction, I would like to say that you see, the judiciary has two functions. One is the administrative function and the second is the judicial function. Judicial function is when judgments are delivered. The administrative function is running of the day-to-day affairs of the court, whether it is the district court, whether it is the high court, or whether it is the Supreme Court. So I would like to just address a little bit about administrative issues in the Supreme Court. And one of the most important areas that has to be considered, about which there is a lot of debate that is going on, is with regard to the appointment of judges. How are judges appointed in the High Court and how are judges appointed in the Supreme Court? The procedure is that every High Court has a collegium of judges, that is the Chief Justice of the High Court and two senior most judges. Similarly, the Supreme Court also has a collegium. When they are dealing with the appointment of High Court judges, you have the Chief Justice of India and the two senior most judges. When they are dealing with the appointment of a judge to the Supreme Court, it is the Chief Justice of India and the four senior most judges. Now, in my view, the meetings of the collegium, whether it is the High Court or whether it is the Supreme Court, I think it is necessary that the meetings should be transparent, which is to say that it is not as if there should be a camera, when the discussions are going on, but what are the discussions that have taken place, that should be placed on record and it should be made available. When some person has been recommended for appointment, what are the factors that have been taken into consideration for making that appointment? The question is not of rejection or saying that no, this person is not fit to be appointed. The question is that whom are you appointing and why are you appointing that person? I can tell you that I am also a judge in the Supreme Court of Fiji, and I was told by the Chief Justice of Fiji that they have a Judicial Service Commission which deals with appointment of judges, and the proceedings of the Judicial Service Commission are recorded. So there is a transcript that is available with the Judicial Service Commission, which gives an indication of why they have considered certain persons and why they have accepted certain persons. There was a move at one point of time to have a video camera of the proceedings of the Judicial Service Commission, but that was not accepted and they are continuing with the procedure of recording the proceedings. Now, if they can do that in a small country like Fiji, I do not see any reason why it cannot be done in India as well. So really there should be transparency in the discussions, in the appointment procedure, so that people know what is happening. Now, one of the things that people say is that, oh, you see, we don't know who is being recommended for appointment. A few days ago, for the first time, I saw in the newspapers an item which said that Allahabad High Court Collegium has recommended the appointment of, I think, about 12 judges. Now, it is the first time that it has come out in the newspapers that a High Court has made a recommendation and it has come out in the public domain, in public knowledge. The names were not disclosed. But the fact of the matter is that everybody in the bar association, the lawyers, they come to know within a day or within 2 days who are the names who have been recommended, who are the persons who have been recommended. So really, when the High Court makes a recommendation of persons to be appointed as judges, I see absolutely no reason why the names of those persons should not be disclosed, because everybody knows it in any case. If they don't know it today, they will know about it tomorrow, or they will know about it day after tomorrow. This is practical experience, and it is not something which is like a secret or something. If it is a secret, it's an open secret. Everybody knows who the persons are who have been recommended. So this entire procedure, has to be transparent. I will give you two examples of how the collegium functions and why there is so much talk about recommendations and why persons are being left out. There was a incident in Punjab and Haryana High Court, I think about 14 or 15 years ago, where the Chief Justice of the Punjab and Haryana High Court wanted to recommend some persons for appointment, but the other two judges in the collegium said, no, we do not agree. We think that these persons should not be recommended. The Chief Justice said, all right, I will take your objection on record, but I will send the name in any case, because as the Chief Justice I have to make the recommendation, so I will send the name. And the names were sent by the Chief Justice of Punjab Haryana High Court with a note from the other two judges to say that we don't agree with these two names, or three names, whatever the number was. Now the Supreme Court Collegium considered the request of the Punjab Haryana High Court, and they agreed with the Chief Justice, and they appointed those persons as judges of the Punjab Haryana High Court. So really, again, there is this dialogue, there is this discussion which takes place. You have one point of view, somebody else has a different point of view, and then somebody takes a decision, final decision. You may not be happy with that decision, but at least you have been consulted and your views have been taken into consideration. The second example that I want to give to you is from the High Court in Telangana. Now recently the same thing happened. The Chief Justice said, I would like to recommend the name of certain persons for appointment as High Court judges to the High Court of Telangana. The two members in the collegium, they said, we don't think these persons should be appointed and we reject your request. The Chief Justice said, well, I am the one who has to decide. I am the one who has to make the recommendation. So you please give your objections in writing and I will send it to the Supreme Court for consideration. Now, before that was done, before the recommendations were actually sent, the two judges who had disagreed were transferred out. Right? So they had orally said that we do not agree with the recommendation made by you. One person was transferred out to some high court, another person was transferred out to another high court. Two new persons came into the collegium, and the Chief Justice said, well, these two or three persons should be appointed, and the other two judges agreed because they had the experience of the others being transferred out. So really, how the collegium functions, what actually happens in the collegium. We don't need to have a video recording to say that, well, this is what is happening and this is not what is happening. But we need to know what are the essential factors that are taken into consideration. Why has a particular person been recommended? What are the factors that you have taken into consideration? I think that is a very important aspect of the right to information. Now, you also have instances of district judges who have to be appointed to the High Court as High Court judges. Sometimes, not sometimes, but very often, senior most persons are superseded. Why are they superseded? We don't know. We need not know, because that's in a sense a rejection. But why has somebody else who is junior, why has that person been appointed as a judge of the High Court, overlooking the 2 or 3 or 5 senior persons? I think as citizens of the country, we have a right to know why this should happen, because we are governed by the rule of law. Those persons will deliver judgment, and we must know persons who are persons of integrity who are being appointed. The same thing happens when judges are being appointed in the Supreme Court. Senior most persons are overlooked. Why are they overlooked? Why is it that a person who is number 30 in the seniority list jumps over 29 persons who are as good, if not better? In some cases there are persons who are much better. A person who is number 30 is appointed as a judge of the Supreme Court, but number 1 to 29 are overlooked. What is the reason for that? Again, as citizens, I think we have a right to know this. Number 15 is appointed. 1 to 14 have been rejected. Why? 16 to 29 have not been recommended. Why? So, I think this is all a facet of the right to information, the right to know who are the people who are going to deliver judgment in a case that is filed by any one of us, and why have these people been selected as against other persons who are senior to them, who have more experience, and in many cases persons who are much better. We've had, I can tell you recently, we've had the senior most judge in India. I'm sure you're aware of his name, Justice Akhil Qureshi, one of the best judges, one of the finest judges in the country, not appointed to the Supreme Court. Why? We don't know. We can guess that this is the reason why he was not appointed. But these are all rumors. We don't know. What is the fact? Why is it that he has been overlooked? Why is it that somebody who is much junior to him has been taken up? What is so great or what is so good about that junior which you are finding is lacking in Justice Akhil Qureshi? A man of great integrity, a man of great wisdom. I have had occasion to go through his judgments on several occasions while I was in the Supreme Court. Excellent judge. Why has he been overlooked? We don't know. So there will be rumors. This is what happened, he did this, he did that, and that is the reason why he has been overlooked. But what is the truth? We will never get to know unless somebody in the collegium speaks out. Recently, the Chief Justice of India had said that, you cannot judge the judiciary on the basis of one judgment. You can't say that, this one judgment is not correct or not good, and therefore say that the judiciary itself, there is a problem. He's partly correct, but I think he's mainly wrong. You will remember that during the emergency, we had the judgment in the case of ADM Jabalpur, where the right to personal liberty was taken away. Out of 5 judges, only Justice H.R. Khanna disagreed with the other 4 judges. The other 4 judges said, when there's an emergency, you don't have the right to personal liberty. So actually somebody can come to your house and say that Mr. X, we are arresting you under MISA. And you say, I'm not Mr. X, I'm Mr. Y. The police can say, it doesn't matter. We are arresting you. So that was the import of the judgment in the ADM Jabalpur, also known as the habeas corpus case. That one judgment destroyed the credibility of the Supreme Court. Fortunately, after the emergency was over, people forgot about that judgment. Nobody has ever referred to that judgment at any point of time. Again, Justice Qureshi. The rumor is that one judgment that he gave sealed his fate. Again, you're depending upon one judgment. There are so many instances where because of one judgment people have had to suffer. We had a judge in Delhi High Court who gave one judgment, not even a judgment, it was an interim order. When we had riots in Delhi, the judge said that, people who have been injured, they should be treated in the hospital. What happened? 11:30 at night, he got an order transferring him out of Delhi. One order, not even a judgment, but one order. They said, you go out of Delhi with immediate effect. Normally, 15 days time is given so that the judge can wind up his affairs. If there are any judgments to be delivered, those judgments can be delivered. But not in this case. They said with immediate effect, you go. One interim order. I can give you several such instances where you've had persons who have been victimized, judges who have been victimized, who have had to bear the brunt of the problems that have been created because of one judgment or one order. Coming back to the functioning of the collegium, there was a book recently released by a former Chief Justice of India, who is now a member of the Rajya Sabha, nominated member of the Rajya Sabha, where he has disclosed certain events that took place in the collegium. Now, look how strange it is. You see, on the one hand, all of us are told that what happens in the collegium is secret. Okay, you should not know anything about it. It is not transparent, it is completely opaque. But then you have a Chief Justice of India who writes in a book that this is what happened in the collegium. What happens to the secrecy aspect? Do you call him a whistleblower? What do you call him? A person who has betrayed the confidence of the collegium and has disclosed what has happened? And in this particular case, unfortunately, it's very unfortunate, what the Chief Justice wrote was not correct. He just made up a story and said, well, this is what I think happened, and I'm putting it down so that it is there on record that this is what happened. But what he has written is not correct. I know it because I was a member of the collegium at that time. So where do you draw the line between secrecy, between opacity, between being opaque and the right to information? Is it that the right to information is not available as long as you're a judge of the Supreme Court, as long as you're a member of the collegium? But you come out of the Supreme Court, you retire as a judge, the aspect of secrecy goes, the right to information comes in, and you're free to say whatever you want to say. So I think these are things which we need to actually look at and decide where are we going when we talk about secrecy, when we talk about opacity in the collegium, and where we talk about the right to information. Now, the purpose of the right to information is of course good governance. We all accept that. It is also to expose corruption. A former Chief Justice of India, sometime I think in 2000, 1999, 2000, around that time, 1998, 99, he said that 80% of the judges are honest. Now, what does that mean? When he says 80% of the judges are honest, does it mean that 20% are not honest? Or does it mean that he has got information only about 80% and all those 80% are honest? What does he mean by that? So again, if you look at the right to information and you look at corruption as an aspect which needs to be exposed, which needs to be uncovered, how are you going to do it? If everything is secret. And if you come out with something like this, if somebody says, a former Chief Justice of India said that, but I think if any one of us says that, only 80% of the judges are honest, the next thing you know is you will get a notice for contempt of court. So, what do you do? Where is the right to information as far as the judiciary is concerned? I think we need to debate that, we need to discuss that, we need to understand where are we going in this direction and how far can we go and how soon can we go. I think we need a detailed discussion on that. The second aspect that I would like to deal on this issue about the collegium is with regard to transfer of judges. Now, I had mentioned to you about a judge from Delhi High Court who was transferred overnight. Other judges have also been transferred overnight. No reason given. The only reason given is the better administration of justice. Now, what does that mean? Does it mean that the judge is not doing a good job and the administration of justice is suffering because of that judge? If it is correct, what is the Chief Justice of that High Court doing? Why is he not, running the administration properly? Is it a reflection on the Chief Justice? that one of your judges or two of your judges need to be transferred out because they are not helping in the administration of justice. And if that judge is transferred out from one high court to another high court, how is that going to improve the administration of justice in that high court? We don't know. So this entire transfer policy, without giving any reasons, saying that, oh, you see, it is in the interest of the better administration of justice, really means nothing at all. The fact is that the person is being transferred out because somebody somewhere wants that person to be transferred out. And the collegium says, okay, we will transfer out that person. Action can be taken against that judge who is hampering the administration of justice. There is a procedure available for that. But that is not being resorted to. If you have something against a person, if you feel that a judge is corrupt, hold an inquiry against him. Inquiries have been held against judges in the past. I was a member of a committee where an inquiry was held against a judge. We found that judge guilty, we made a recommendation, but nothing happened. That judge remained in that court. That judge retired from that court. No transfer, no action. Where is the better administration of justice in a situation like this? I think we need to ask all these questions. Again, you have instances in the district judiciary of judges being transferred without any rhyme or reason. Recently, last week, there was a case where it was a case of sexual harassment. The district judge said that, oh, you see, the lady was wearing a dress that was sexually provocative, so therefore there is no sexual harassment. What did the High Court do? The High Court said, we are going to transfer this person. This person filed a petition in the High Court and said, well, this is my opinion. My opinion may be wrong, you may disagree with me, but you as the High Court can set aside my judgment. Say my judgment is wrong, it is a wrong judgment, it is a ridiculous judgment, say whatever you like, set it aside and say that yes, it does amount to sexual harassment. But how is transferring me going to make a difference? Because I am going to still hold that view. And the High Court said, well, you can't transfer the person because you do not agree with the opinion of that judge. So the situation can be that if your opinion is not acceptable to somebody who is higher up in the hierarchy, you can be penalized for it. We have judicial academies in different parts of the country. In every state we have a judicial academy. Judges can be sent to the judicial academies for training, for education. That how do you write a judgment? What do you take into consideration when you're writing a judgment? Don't make statements like this. Don't express your personal opinion in a judgment. But again, that is not resorted to. You transfer the judge and say, well, let us see what happens. And then the High Court itself stays the transfer. Where does that lead us? Was the judge right or was the judge wrong? Was the process right or was the process wrong? What is it? What do we as common people understand from this? I would like to now shift my focus to judicial matters. That is the second aspect of the judiciary. Again, I think we need to be a little more open in our judicial process. I'm very glad to tell you that the webcast of court proceedings has started in many high courts. Gujarat High Court it has started. Here in Orissa it has started. And yesterday live streaming or live webcast of proceedings in 30 districts is going to start. There is going to be a bit of a problem initially. Teething problems are bound to be there. But yesterday the Chief Justice of India had come. He was here in Cuttack and he has launched the webcast of the live streaming of proceedings in 30 districts, in all the 30 districts of Orissa. I think that is a very great achievement, and the people of Orissa should be proud of this, that it is their state where for the first time in every district you are going to have open proceedings. I don't think there is anything wrong in this. We have parliamentary proceedings which are telecast live. What is wrong with judicial proceedings? As a person who is sitting anywhere in any part of the country, I would like to know what is happening. What is the law that is being laid down? Not only in the High Court but also in the Supreme Court. In the Supreme Court it is more important because the judgments of the Supreme Court are going to be applicable throughout the country. So we should have live telecasting, and I hope within this year or maybe early next year we should be in a position to have live telecast of proceedings in the Supreme Court. A senior advocate has sent a letter to the Chief Justice of India 2 or 3 days ago saying that in important constitutional matters the proceedings should be telecast live, so that we know how is the Constitution of India being interpreted by the Supreme Court. I think about 15 years ago in Canada, in the Canadian Supreme Court, there was a very important case that was going on involving some constitutional issue. A lot of people had come. They wanted to attend the proceedings, but the courtroom was of course not, could not accommodate so many hundreds of people. So some people came, others were standing outside. Speakers were installed so that, loudspeakers, so that they could hear what is happening. And after that, the Supreme Court of Canada took a decision that we are going to telecast our proceedings live. So today there is a dedicated channel on the television in Canada where the proceedings of the Supreme Court are telecast. Why can't we do that in India? We can start with important constitutional matters, and many of them are going on at the moment. We can start with that. Now, similarly, I have mentioned to you about, proceedings of the Judicial Service Commission in Fiji. But in the courts in Fiji, everything is recorded. There's no cameras. I mean, they don't have that kind of facility, but everything is recorded. The first time I was sitting, in the court, I asked some lawyer a question, and the Chief Justice told me, speak a little louder, speak into the microphone so that the lawyer can hear you. I said, the lawyer is standing just in front of me. He can hear what I am saying. He said, no, he can hear what you are saying. There's no difficulty about that, but all this is being recorded. So after that, I had to speak in the microphone. So the entire proceedings are recorded. What is wrong with that? It's healthy, because again, that's a part of the right to information. A lawyer might say, and it has happened, that I have argued a particular point in court, but the judges have not noticed that point. What is the proof of that? It will be, if there's a live telecast, a recording. If there's an oral recording, that is there as proof. But otherwise, what the lawyer says and what the judge says, only they know. The lawyer says, well, I said this. The judge says, no, you did not say it. Now, whom do you believe? So, as a part of, understanding the legal system, understanding how it works, I think the right to information must be made available to everybody, whether, like I said, in administrative issues, but also in judicial matters. Why do I say this? I say this because it was mentioned that public confidence and public trust is important. You must have full faith in the judiciary. You must have full confidence in the judiciary. And the judiciary should be in a position to give you full faith and confidence and trust that what we are doing is right. We are not influenced by anything. The oath of office says without fear or favor, without affection or ill will. The only guidance is the Constitution of India. Now, if people don't have that confidence, how is the judiciary going to survive? Today there is a lot of talk about post-retirement benefits, and this is the last point that I would like to make. Post-retirement benefits. Why are judges being nominated to Rajya Sabha? Why are judges being given governorship? Is it because, when they're judges, they can give judgments in favor of the government? Let me tell you that this is a matter of integrity. We have had instances in the past. I can tell you immediately of 2 or 3 instances. Before independence, the Chief Justice of India was one Sir Maurice Dwyer. While he was Chief Justice of India, he was also the Vice Chancellor of Delhi University. Now, please think today, if you have the Chief Justice of a High Court or the Chief Justice of India functioning as the Vice Chancellor of a university, you can imagine what will happen. But the people had confidence in him. Okay, we can say that this happened before independence. I can tell you after independence. After independence, we had a former Chief Justice of India, Justice Gajendra Gadkar. After his retirement, he was appointed as Vice Chancellor of Bombay University. Now, if you look at the protocol, from Chief Justice of India, he is appointed Vice Chancellor of Bombay University. Nobody raised a finger. Nobody made any criticism. Why? Because he was a man of great integrity. He was a man of great learning. They said, yes, he is the kind of person we need as a Vice Chancellor. You had another person of great integrity, Justice M.C. Chagla from the Bombay High Court. After his retirement, he was appointed as a cabinet minister. He was Minister of Education. No fingers raised. Nobody said, oh, post-retirement benefit. He was India's High Commissioner to London. Nobody said anything. Why? Because he was a man of great integrity. So once you have persons of integrity as judges, there is faith in the public, and whether that person gets a post-retirement assignment or does not get a post-retirement assignment, nobody minds, because they know that he's a man of integrity, he's a man of learning. So good, we need a person like that. But today you're faced with a situation where a judge after retirement gets some appointment, and people say, oh, why has he got that appointment? Is it because he gave a judgment in favor of the government? You have a situation today where on the day of retirement or the day after that, a person is appointed as somebody in charge of a commission or given some assignment. What do people make of it? And this is the reason why people talk about post-retirement benefits. Why did this person get post-retirement benefit? So that while he was a judge, he had favored the government, or he could have favored the government, or he tried to favor the government. It raises an issue of integrity. It was not so 20 years ago. It is something which has been discussed in the last maybe 5 or 10 years and discussed widely. And we have a problem over there, which again we need to discuss again as a part of the right to information. Why is this judge being appointed to a particular assignment or to a particular post after retirement, and one day after retirement? Is there some reason for it? And if so, what is that reason? It's a matter of governance. We as people need to know, and we as people have a right to information on that. So thank you very much, and I would like to thank everybody for this occasion. Thank you.